My name is Shakur. I'm 49 years old. I was born as Colonel Green in the early 70s to a teenage girl who was raised in and aged out of the foster care system. I never met nor know anything about my biological father, except that he's spent his adult life in and out of the prison system. I'm currently serving a 50-year prison term for second-degree murder, conspiracy to commit first-degree murder, use of a handgun and crime of violence, and wearing, carrying, transporting a handgun. I've been locked up for 21 years.
To bring to the public's attention the injustices and abuses of the Baltimore City judicial system and police department. To bring to light another case of how the Baltimore Police Department and State's Attorney Office, along with the complicit cooperation of the judges, use the power of the office to suborn perjury and manufacture false evidence, as well as hide and destroy exculpatory evidence. In other words, they deny due process to those who are supposed to be constitutionally protected from such abuses, but this has been a common occurrence for decades now. Well, my case begins with my little cousin who was 17 at the time, and the 26-year-old social is getting into a street fight in November 2001, around Thanksgiving Day. As my little cousin and then my co-defendant gets into a fight with this older guy, the older guy stabs my little cousin several times. When my little cousin initially gets stabbed, he goes home where he lay bleeding until the paramedics transport him to Johns Hopkins Hospital. After my little cousin was transported to Johns Hopkins, the police arrived and opened an investigation into the stabbing. The older guy identified by several on the scene witnesses. The police canvassed the area, but this older guy is never found by the police. Several weeks after the stabbing, this older guy is found critically shot around the same area where he has been transported to the hospital and pronounced dead. Upon this older guy's death, a homicide investigation was opened. Shortly after the start of the homicide investigation, my little cousin was questioned and released by detectives. A month later or so, my little cousin and his then girlfriend get into a domestic violence situation at my uncle's house where the police were called by the neighbors. The police arrived and decided to lock up my little cousin's girlfriend. While she was in police custody, she made a statement in which she claimed to be a witness to the alleged planning and execution of the older guy's murder. In the statement, my little cousin's girl named me, my little cousin, his sister's boyfriend, my uncle, whom she alleged gave me the bullets and gun to commit the murder, but only me and my little cousin were arrested. My little cousin and I were held at Baltimore City Detention Center about 2 years before others went to trial. This is the short version of how my 20-plus year ordeal began. It sounds like any other case I had continually throughout the inner cities of the USA, but this case is rife with prosecutorial abuses such as backdoor dealing, hiding and/or destroying exculpatory evidence, witness intimidation, and the use of government resources to manipulate witnesses and their testimonies so they will fit the state's narrative of events. Well, I've been actively challenging my conviction through the court system for the past 20-plus years. Through this ordeal, I've discovered that the police possess 4 tape statements that I never had access to. This was discovered about 10 years ago. Since this discovery, I've been fighting to get these statements, but the police department said they would not give me these statements without a court order. Over the past 10 years, I've petitioned the court as well, submitted several Public Information Act requests. When I finally compelled police records to give me these statements, I was told that it no longer had these statements because they were signed out a day before I picked my jury and were never returned to police custody. Police records said this happened 20 years ago in September 2003. I'm presently seeking a copy of police procedures in regards to the handling of evidence in police custody from everything I've learned through informal channels. This incident of signing out evidence and not returning it is a direct contradiction to standard protocol. And the police records supposed to have certain mechanisms in place to safeguard against these kinds of situations. But this latest incident fits perfectly this pattern of behavior exhibited by Baltimore City Police Department throughout my 20-plus years of incarceration. The credibility of the state's alleged sole identifying witness, the credence of this witness's statement were juxtaposed to crime scene photos procured by my folks and Google Maps of the crime scene area, transcript statements from my trial and post-conviction hearings, mugshots, correspondence between me, the police department, and state's attorney, docket of entry, and much more legal documents. There are a lot of moving parts involved in this ordeal, and I hope that I'm able to coordinate everything in a comprehensive and understandable manner. Well, despite the police documents reporting that this murder happened midday in front of a neighborhood of people, there was only one person who identified my little cousin and me as the alleged culprits, which was my little cousin's 16-year-old girlfriend. And this is problematic in a number of ways. First, 95 to 99% of a statement was uncorroborated. Only a short portion of a statement was corroborated, which could have been repeated by anybody who heard gossip off the streets. And the portion I'm referring to is when she allegedly saw me run to a getaway car after I allegedly shot and killed the victim in this case. As I said before, police reports state that numerous people were in the area when the victim was murdered. And even the alleged witness' own statement, she said my little cousin homies would come to his house to talk about what the block was saying. So anybody who knew somebody from the area could be familiar with this alleged fact. In fact, I believe the purported corroborated witness fits this category because despite the state's assertion made on my trial that the corroborated witness supposedly flagged the police over immediately after allegedly witnessing to what he testified to in court, it came out during my trial that he didn't contact the police until a week after the murder, and only him and not him and his god brother, as he alleged in the statement, went to the police. It came out in court that he testified for the state in another case prior to testifying in my case. During the early 2000s, the police would transport people and lock them up for drug offenses to homicide to see if they had any info about homicides. And if any of them had any info, they could use the info to get out of being locked up for the drug offense. But if a person wants to avoid being locked up bad enough, he or she would say anything to avoid jail. Sometimes he or she will make up him or herself a witness to a murder by passing info they heard off the street as if he or she witnessed it. And I believe this is the case with the so-called witness that corroborated the enforcement of my little cousin's girl initial statement. I say initial because she recounted at least twice. Once to my little cousin's attorney shortly after me and my little cousin were arrested, and the second time in court during my trial when she was compelled to testify. In fact, her initial recanted statement became the center of a dispute in the pre-trial stage of my conviction. My little cousin's lawyer recorded his girl's initial recanted statement. The prosecutor found out about it, and in order to squash the recanted statement, they asserted that my little cousin's lawyer illegally and improperly questioned her and coerced her into making a false statement, and so to have him removed from the case. My little cousin's lawyer and the state made a backdoor deal, as well as my lawyer, that the statement wouldn't be used during our trials. While my lawyer, who wasn't a party in the controversy, would agree to this can only be explained as intentional sabotage, because the recanted statement and issue could have been used by my attorney to rehabilitate my little cousin's girl testimony when she recanted on the stand during my trial. This falls under Maryland Rule 5, 616C2. My little cousin's girl's credibility is also questionable when one considers that she had a long history of mental illness, where it was documented that she would embellish the truth to gain attention. Then here's a whole case as serious as mine, when an uncorroborated word of a person with such a problematic history is crazy. In fact, that one observation of how my little cousin's girl embellishes the truth to get attention was never allowed to be heard by the jury due to the blatant judicial abuse and gross incompetence of my trial lawyer. So the jury never knew why somebody like my little cousin's girl would make such outrageous accusations if they weren't true, which is logically understandable because no one in their right mind will make up these kinds of accusations. In her statement, she said she was at a meeting purportedly attended by me, my Uncle Ronnie, my co-defendant, and little cousin, his sister, her boyfriend, where she heard us planning the victim's murder. She also allegedly witnessed my uncle give me a gun and bullets to murder the victim. This alleged meeting was never corroborated by anything or anybody. And also keep in mind that no one except me and my little cousin, even my uncle who allegedly gave me a gun and bullets for the murder, were ever charged. When the detective was questioned about not charging anyone else in the conspiracy, he said he didn't have enough evidence against the other alleged co-conspirators. I don't want anyone else entangled in this bullshit. But if all allegations weren't enough to charge them, how in the world were they enough to charge me and my little cousin? The police, with the prosecutor's help and judge's complicity, cut and paste the case to fit their narrative. My little cousin's girl also alleged she witnessed my little cousin call me to kill the victim, saw me come to my little cousin's house, me and him walk 2 blocks from his house to the area where the victim was standing, saw my little cousin point the guy out to me, saw me buy him a bed, approach and shoot the victim, and saw me run 2 blocks up the street to a getaway car to flee the scene. The problem with this statement is the likelihood of her saying everything she alleged, like saying me make a turn on Oliver Street. See, one would have to be directly on Milton, allegedly where the car was parked, in order to see someone make a turn on Oliver, because there are row houses along these streets which would block someone's view from around the corner. So after she allegedly saw me shoot the victim 2 blocks down from Milton on Mumford, she afterward had been running beside the gunman or directly behind the gunman in order to have seen the gunman shoot the victim, run 2 blocks to the alleged getaway car, drive off, and make a turn on Oliver off of Milton. Keep in mind that the distance between Milton and Mumford is 250 feet or 83 yards, almost the distance of a professional football field. So you're going to tell me that this 16-year-old girl not only had the heart to run with or behind someone whom she just saw shoot and kill somebody, but she also is going to run almost the length of a football field in order to be able to see someone make a turn on Oliver Street off of Milton in real time? She missed her college. She should have been in the Olympics. These are the problem areas of the statement that was never scrutinized by my attorney for the jury to mull over during the deliberations. In hindsight, it's my contention that my attorney was in cahoots with the state to a certain extent. Soon after my little cousin and me were arrested, the state's case started falling apart once the only alleged eyewitness's mental health surfaced. She recanted and retracted her statement immediately after our arrest. Secondly, the state was discovering that there was absolutely no objective corroborating evidence to support the witness's statement. Who could and did corroborate her account about the conspiracy meeting supposed to convene at my uncle's house? Nobody. Was a gun ever found? No. She said my uncle gave me special bullets that exploded when they hit a person. Did the police ever find these bullets or a box that would have housed these bullets? No. Did the police ever find a bill of sale or a receipt for these bullets or any kind of bullets? No. The purported car used in the murder, was I ever linked to this car forensically or by another independent evidence? No. Did the police have any other kind of linking independent evidence incriminating me in the murder? No. Were the alleged phone calls ever corroborated by phone records or other independent witnesses? No. After a careful examination of evidence, one will find that the entire case hinged on the unsubstantiated word of a troubled teenage girl with a lengthy history of mental illness. In fact, this same young girl was committed to a juvenile psychiatric facility during my trial. She was being transported from this facility to the courthouse every day during my trial. One day she couldn't even be transported because she attempted or threatened to commit suicide. To circle back to my original point, I believe my attorney was making certain concessions as some kind of professional gesture, so the state would have a decent case to present to the jury. I believe my attorney thought I would beat the case anyway, so he gave the state some wiggle room, such as not fighting postponements, not fighting certain motions, and other conciliatory gestures. A whole year after I was arrested, the state was still investigating my case, even after my Hick rights kicked in. Hicks is a case that codifies one's right to a speedy trial, which is supposed to be constitutionally protected. My docket of entry, which lists every hearing, motion, and action taken in my case, clearly shows numerous times that I never waived my Hick rights. And in no way did the postponements help me strategically. In fact, they prejudiced me. In other words, they harmed me. And one main and highly important way The postponements hurt or prejudiced me was appearance. Around the time of my arrest, which was almost within the close time frame of the murder, I was over 200 pounds. While I sat in Baltimore City Detention Center for close to 2 years, I lost close to 40 pounds, making me weigh in at 160. This is highly important because this did two things. I became the size I was when I used to box as an amateur during the late 90s, which is the time frame of a mug shot that my little cousin's girl signed in a photo array, identifying me as the shooter. And second, it made me, as I would later discover during trial, fit the description of the alleged corroborating witness. This witness said he saw the hooded guy whom he couldn't identify run up the street with a gun who was 5'6", 5'7", and 150 pounds. Well, that's 50 pounds smaller than I was when I was arrested. But that 150-pound description matched up well with my mugshot in the photo array and what I weighed on the time of my trial. So to any objective outsider, I would definitely fit the description after my 40-pound weight loss of the corroborating witness, even though he couldn't identify the hooded guy. The crazy thing is, I didn't know anything about the corroborating witness's description prior to his testimony during my trial because the prosecutors never gave me his statement during discovery prior to my trial. When I told my trial attorney about my pre-detention weight of 200 pounds and showed him my ID bracelet of how I looked at 200 pounds, he didn't diligently pursue any substantial ways to bring this fact before the jury, except ask a corroborating witness if he had recognized the difference between a 150-pound guy and a 200-pound guy, which he answered yes. Not to get off the topic, but this is a major way that the postponement harmed me. If I would have came to court at my pre-detention weight, would the jurors believe that I was the guy this witness claimed he saw running up the street with a gun, thus giving credence to my little cousin's girl's statement? From my vantage point, I believe that's highly unlikely. I can see why an impartial, objective person could believe it's feasible for me to be the gunman when my trial weight matched the corroborating witness's descriptive weight of the gunman in the photo array picture signed by my little cousin's girl. That's why it was incumbent on my trial attorney as my supposed advocate to use every method available to tell the jury what I weighed contemporaneously at the time of my arrest and time of incident. This is only one of the lapses of effective representation by my trial attorney, which seems intentional since he was a well-seasoned attorney with over 30 years of experience at this time. There are several. In fact, he apologized to me during my post-hearing. But the biggest way he misrepresented me is when he didn't cross-examine the state's only alleged identifying witness, my little cousin's girl. She knew that she lied, so she tried to do everything she could to undo the damage she caused in a brief moment of rage, such as get an attorney, even though she wasn't charged, try to plead the fifth, spaz out every time it was time for her to come to court, etc. Finally, after she was compelled by the state to testify, who bypassed her invocation of her fifth by granting her immunity, she recanted her initial statement again while on the stand at my trial. First, she acted like she couldn't remember her statement, and then under duress by the prosecutor, she admitted fake memory loss because she didn't want to testify. Once she admitted this, it kicked in her hearsay exception rule, Murder Rule 5-802-1, which allows out-of-court statements made by a testifying witness who's available for cross-examination once that person gives an inconsistent statement while testifying. In other words, if a person either directly recants a prior statement given to police or indirectly recants a prior statement by faking memory loss, the prior statement is allowed into evidence under the hearsay exception clause. So, once she admitted that she was recanting her initial statement to police, in short, the statement was played for the jury. As a seasoned defense attorney, my trial attorney should have had cross-examined my little cousin's girl, so she could explain to the jury why they should believe her in-court testimony instead of her initial out-of-court statement. It would also have given her the opportunity to explain how, when she's in an unbalanced state of mental health, she would say anything to hurt anyone she feels slighted by. None of that was explained to the jury. As far as they knew, she was a young girl who didn't want to testify because she felt threatened or she didn't want to be labeled a snitch, a position that most jurors won't be sympathetic to. In fact, the prosecutor said as much in her closing statement. In essence, I was never identified as a shooter by anyone in court, and I was convicted ex parte by an out-of-court statement. No one pointed me out in the court as a shooter. As I stated before, no gun was ever found. No bullets at all was ever found. No clothes fitting the assailant's description was ever found. Nobody ever corroborated her assertion of a meeting to kill the victim. Nothing but the bald allegations of a young girl with a lengthy history of mental illness convicted me. Next, my trial attorney didn't hire an investigator, nor did he survey the crime scene himself to see how my little cousin's girl's statement matched up with the same once juxtaposed bushes. I had my folks take pictures of the area sometime after my conviction. And once I plugged the statement in, the statement didn't make any practical sense. As a side note, my trial attorney allowed the state to use a cartoonist sketch that's supposed to depict how the getaway car was allegedly parked. Mind you, this is a busy residential area with lots of people, traffic, parked cars, and row homes. The blocks are long, narrow streets, so if one is far off down on block, he or she won't be able to see certain points on the proceeding block because he or she will have houses blocking one from seeing around the corner. So this cartoonist sketch my trial attorney allowed the state to use depicted the alleged getaway car is parked far off the corner, which would have made it blocking traffic. The same sketch didn't have any landmarks such as pedestrian strips, fire hydrants, wheelchair ramps, etc. marked on it. This is important because, one, if the car was parked far off the corner as depicted, it would have been blocking traffic at a normally busy intersection. Two, it would have been a glaring parking violation and eyesore, which would immediately grab the attention of a number of any patrolling police who drive around because it's a high crime area. And three, no one who's going to plan to shoot and kill somebody will park his or her car in a way that's going to attract police who will either ticket the car, thus document his presence at the scene, have the car towed, leaving the shooter without a getaway car, or cause the police presence at the car when one is scrambling to the car to flee a shoot. But the state had to depict the car this way in order to make it plausible for witnesses to be able to see the shooting and the alleged getaway car simultaneously from a central point. Remember, there's only one alleged witness who claimed to see and know everything concerning this murder. Everything hinges on this one witness. The corroborated witness never claimed to have seen or heard the shooting. He only claimed to have seen someone with a gun running up the street and flee in a white Lexus. In fact, he can't even claim to know the person with the gun was running from a shoot. As far as he knows, the gunman was an actor and the gun was a prop. He didn't have enough info to substantiate his initial conclusion unless he got word off the street and or he made a connection to what he said he saw. At any rate, my trial attorney did a sad-ass job poking holes in the so-called corroborated witness's account. And according to this witness, it was him and his guard brother who allegedly saw everything. But it was only him in the courtroom. And the prosecutor didn't subpoena the other alleged witness. This is highly suspect, especially in light of the fact that this guy is some kind of professional witness for the state. Next, my trial attorney allowed the prosecutor to falsely tell the jury during closing arguments that my little cousin's girl said that she saw me with a semi-automatic handgun, which she never did, either in court nor in her initial statement to the police. The prosecutor did this in order to bolster and buttress my cousin's girl's statement by making the statement identical to the so-called corroborated witness's testimony. See, if two people who never met or dealt with each other say the same thing, then the chances that they are lying are damn near impossible. But the prosecutor knew this. That's why she made the slip during closing arguments. Closing arguments are the most contemporaneous parts of the trial to deliberation, where the jury decides guilt or innocence. So whatever is said during closing arguments is going to be the freshest on jurors' minds during deliberation, potentially having more impact on their decisions. There are many legally convoluted errors committed by my trial attorney that I will not list because these aren't the points I want to highlight. The parts I want to highlight are the events that occurred during my post-trial. Well, it's been a long and hard process thus far. After I was initially convicted, the direct appeal process began. During the preliminaries of the process, a large part of my trial transcript came up missing, one of the most important days of the entire trial. We had a hearing to discover what happened to this transcript. At first, no one had a clue about his whereabouts, and then lo and behold, the transcript appeared out of nowhere. This is important because the transcript is a verbatim record of what's said during the trial, and a record the higher courts used to ascertain the legal propriety of the trial. This missing transcript was the record of the trial day, which the only purported incriminating evidence against me was omitted. My little cousin's girlfriend's statement to the police. So the transcript was discovered and the appeal process proceeded. Two interesting things happened during my direct appeal. Two issues that could have gotten my conviction overturned was botched by my trial attorney. One issue wasn't preserved for appellate review, and the other issue was made null and void by my trial attorney's lack of due diligence. Both of these issues pivoted around evidence stemming from my little cousin's girlfriend. The first issue is that I contend the court improperly involved me from presenting medical records from a psychologist who had interviewed my little cousin's girl years before, which said that she embellishes lies, the truth, in order to get attention. This is highly pertinent because the jury has the right to know how credible a witness is, especially when one is the only incriminating witness. A person's veracity is everything when his or her testimony is proper, is factual, and unbiased, especially in a case like this where a person's character and credibility is everything, where a person's statement is the only incriminating evidence heard by the jury. Without that statement, there's absolutely no evidence incriminating me whatsoever. So the jury had every right to hear evidence and causing to question her credibility. Without the jury knowing about her propensity to embellish stuff, the obvious question would be, why would she make up such an elaborate story? Initially, my trial attorney motioned to have the medical records entered into evidence, but the trial judge denied the motion. When the judge denied the motion, she told my attorney he could reissue the motion, which he did. The Court of Special Appeals said the trial judge didn't permanently bar my trial attorney from entering the medical records into evidence. And since my trial attorney didn't reissue the motion, later during trial, he introduced the records. The judge didn't improperly bar the jury from seeing the records. The second issue, which wasn't for appellate review by my trial attorney and was cited in footnotes of the Special Court of Appeal decision brief, is the one which the court said I didn't raise the issue of the trial court's impropriety of allowing my little cousin's girl initial statement to be played for the jury before it was authenticated, meaning that my trial attorney allowed a statement that supposedly incriminated me into evidence without verifying whether if the statement was a contemporaneous one of the person the state alleges is on the tape. Plus, Special Appeals Court hint that the state also improperly allowed the jury to hear the statement again even after authentication. My little cousin's girl also testified that the detective manipulated the tape statement by making her repeat answers while turning the recorder on and off. That may explain what I mean by preserving for appellate review. In a court of law, in order to preserve an issue for appellate review, a lawyer has to object and state his or her grounds for objection, thus bringing the issue to the court's attention, allowing it to correct the issue contemporaneously. Authentication is the act of proving something as a document is true or genuine, especially so that it may be admitted as evidence. It's a steps taken by the court within its jurisdiction to ensure that an article of evidence is true and genuine before submission to the jury. These lapses were crucial in my case because they pivoted around the only alleged identified witness and the only purported incriminating evidence. So the authenticity of this statement and the credibility of this witness meant everything, as I said before. So I went through the appeal process and I was denied relief. My next major court proceeding was my post-conviction hearing. The post-conviction hearing is a proceeding where most convicted persons asserts his or her Sixth Amendment right to counsel was violated by his or her trial attorney with ineffective assistance of counsel. In the landmark case Strickland v. Washington, the Supreme Court ruled that a defendant not only has a right to counsel, but also has a right to effective counsel. In short, the Supreme Court said that an attorney has an obligation to perform up to a certain or minimum standard. During this proceeding, my post-conviction attorney cross-examined my trial attorney, citing him as ineffective for not objecting to the state as false evidence during closing arguments, for not asking for a continuance in procuring medical records that would have shown my contemporary weight during the time of the incident, which was totally different than the corroborate witness's description, for allowing the state to shift the burden of proving guilt onto me, etc. Any attorney cited for ineffectiveness can normally defend him or herself by asserting a trial tactics defense because the Supreme Court said there is no cookie-cutter way of defending clients and trial tactics varies on a case-by-case basis. My trial attorney conceded to ineffectiveness because he did not oppose it by asserting a trial tactics defense. In fact, He apologized to me twice during our post-hearing, but the post-conviction judge ruled not only that my trial attorney Lashes didn't prejudice me, he also ruled that no errors were committed. He also asserted and inserted his own reasons why my trial attorney didn't take the steps I cited him for not doing, even though my trial attorney didn't assert these things for himself when he was cross-examined by my post-attorney. The hearing proceeded as expected, and I didn't get any relief. As a side note, while preparing for my post-conviction hearing, my post-attorney submitted a Public Information Act request on my behalf to get a copy of my case file, which was in the custody of the police department. In fact, he notified police records he would do an in-person inspection because he felt he didn't get the complete file. According to the Public Information Act statute, any government agency is obligated to make info it possesses accessible to the public, as well as info about the official acts of public officials and employees, and the agency is obligated to turn over this info in a timely manner. If an agency decides to deny a PIA request, it must do so in writing in a timely manner along with info of how to appeal the denial of the PIA request. This info will become germane later on. My post-conviction hearing was held 2010. In 2013, I paid $200 for a copy of my case file from police records. It sent a file full of innocuous documents. Within the case file were blank pages, menus, and other nonsense. They did this to say they sent the proper page count, but I knew I didn't have a complete case file because there were statements used at my trial that weren't in the file. When I wrote public record statements, it then sent additional papers to say there were 4 additional statements that were separated and logged under a different property number, and that they wouldn't give them to me without a court order. Initially, I was so despondent that I didn't get what I was looking for that I bypassed the part about the 4 statements. The whole part of getting the file was to get the statement from my ex's daughter. Prior to my trial, detectives interviewed my ex's daughter after they learned from my ex that a car in question was bought by my ex for her deaf daughter, who was married with children. In this statement, my ex's daughter said she had the car, used the car to get to work, and that I never drove nor had access to the car. My ex knew about this interview personally because the police used her as an interpreter since her daughter is completely deaf. All this came out during my trial, and when it came out, my trial attorney immediately asked for the statement, which the state attorney denied had. The lead detective denied taking the statement, but admitted that he had other detectives take the statement. He denied taking the statement, but he damn sure went to my ex's daughter's house and took pictures of said car, which were used as evidence in my trial. My ex's daughter's statement was not in the case file. I bought copies of it from police records. Around 2015, I petitioned to have my post-conviction reopened. According to law, a convicted person is only allowed 1 mandatory post-conviction hearing. I believe this law stems from the anti-terrorist law passed on the Clinton administration. This law limits post opportunities to convicted persons, as well as limit his or her time to file for a federal habeas corpus in which a convicted person can challenge his or her conviction in federal jurisdiction. While preparing for my reopened petition, I had my father take a plethora of pictures of the crime scene area, as well as give me a Google map of the area. My reopening had a slew of issues that I raised. In fact, it probably was too long, but I'm saying this for a reason. One of the issues I raised in the petition was how my trial attorney was ineffective but not cross-examining my little cousin's girl, which he would have known to do if he had surveyed the crime scene directly or through an investigator. As a side note, an attorney cannot reasonably use a trial tactic defense if he or she did not do a proper and adequate investigation in which to base those tactics on. In other words, my trial attorney cannot reasonably say that he did not cross-examine my little cousin's girl as a trial tactic because he did not survey the crime scene landscape in order to determine whether or not her statement reasonably fit the crime scene landscape. To make a long story short, I raised a slew of other issues on my post-reopening that will be mind-numbing to list. My lefty reopened petition was summarily denied within weeks of me filing it. I was denied so quickly that there's no way it was seriously considered by the court. See, pro se petitioner, those who rep themselves, are normally denied relief by courts regardless of how meritorious their claims. I believe this is part of the judicial system racket. See, judges and prosecutors are lawyers as well who make a plush living off of charging people ridiculous prices for services when in private practice. If people could successfully rep themselves in court, who would pay those outrageous legal fees? All lawyers are part of the same fraternity and as such, are going to ensure each other can eat. That's why one often sees prosecutors become defense attorneys and vice versa. And both of them are the ones appointed as judges. In my opinion, it's one big racket. That's why prisoners will often draw up their own petitions and hire private attorneys to sign their names on the petition to make it look good for the courts. These are hip to the game. In 2020, while talking to some friends, one of them helped me write up an MPI aid request. As I searched through my paperwork, I found a letter that talked about the 4 tape statements. That's when I became determined to get these statements. So I made an MPI aid request for these statements. Right after I made this request, the country was shut down by the COVID pandemic and the courts were closed. So I waited until the courts opened back up before I took any more legal actions. My request went unanswered, a direct violation of the PIA statute, which states that public agency must act within 30 days, and even if they deny this request, they must do so within 30 days by sending the denial in writing along with the law that gives them the right to deny the request and the info on how one can appeal the denial. Baltimore police records didn't comply with any of these requirements. They simply ignored my request. So, in the beginning of 2021, I petitioned Baltimore City Circuit Court to order police records to release the tape statements to me. They denied my petition. Most likely this happened because I didn't pursue the proper legal avenue. I was supposed to file for a judicial review, but I didn't know about their legal procedure, and the courts didn't explain it to me neither. But I wasn't deterred because I was determined. I filed another MPIA request to begin the process all over again. Next, in 2022, I filed a motion for a new trial based on newly discovered evidence. The tape statements with a subpoena for the tape statements attached. Before they filed my motion for a new trial, they dismissed my subpoena saying I had no case on file. Mind you, the subpoena was attached to the petition. So why did they decide to address the subpoena before filing my petition? Right after they dismissed my subpoena, they filed a petition for a new trial. Coincidental? I think not, but these are the games that the U.S. court system plays with regularly. But as I said previously, I'm determined, so I wasn't deterred. A few months later, I made another MPIA request. This time they complied with the request. Maybe because I sent it to another address, which is close to police headquarters. As I said, they decided to comply with the request. Initially, after they decided to comply with the request, they asked me to be patient as they gathered the statements in question. Then a month later, they wrote me saying they couldn't locate them because they were signed out in 2003 for a court proceeding and would never return. How convenient. Right after receiving this info, I made another MPIA request by email via my big brother asking for the standard procedures for evidence, chain of custody, which they initially ignored once more. This time I contacted the office of the public access ombudsman located in the Attorney General's office. After contacting the ombudsman office, police records sent me some of the info I requested originally. As a side note, between 2021 and 2022, I wrote the integrity unit that was headed by former state's attorney, Marilyn Mosby. I had sent the unit a paper I wrote about my case called the Dred Scott Expose. They never did get involved in my case, so I'm pursuing unorthodox methods. I'm still fighting to this day for my freedom.
Okay, to wrap up this presentation, I don't even so close of myself because that would be insensitive to the family and friends of this case's victim. Let me repeat, I did not do this, but I'm not involved in violence. I was living a lifestyle that made me a flawed focal point of some young and misguided young kids. My name was never inserted into the situation. As far as the aftermath and impact of open policies, recently I asked my son how did it incarceration affect him growing up. He told me, he said, by you being incarcerated, I was always looking for this involvement. I didn't know how to handle things, how I managed it. So I handled things how I saw my mother and grandmother. Instead of handling things like a man or I use my emotions to handle things most times in my life. He said I would have had a better outlook in life if I had a father figure right there in my presence. So shit like the way I treat women, I wouldn't be so quick to argue with them. So I'm right there with you, I see you. It's really hard for me to establish a relationship with you. I said, I can't really know you until I'm next to you or around you. But people change, so we need to sympathize with people when they do change. Things like school wrecks, man, and things of that nature, as well as fathers not being there to hold kids accountable. is a very big thing. Boys respect men differently than they respect women because they understand the consequences of the art. In the movie Sicario, the CIA knew that when certain key figures in the cartels were removed, that all outspoken rules were spread among different cartels. So what is the aftermath of broken window policies? Me, I believe, is a great contributor, if not the greatest contributor, to the high rate of juvenile violence that's plaguing this country today. Because you gotta have strong individuals to make strong families. You gotta have strong families to make strong communities, and you gotta have strong communities that make a strong nation. When certain individuals or key figures are taken out of their places like mothers and fathers, they undermine the family dynamic. That's destroying communities and people. So you have the Baltimores, you have the Chicagos, you have the St. Louis, and so on and so on and so on. In fact, my son, he got into a bit of trouble himself, and only by the grace of God was he able to stay out of prison. It's hard to really explain because the impact is so much. In fact, I've had thousands of donors that certain events like the Brooklyn Rosemary Street, the school kids that were shot is when one was killed in Henderson Village, a shopping mall. In the time when a young woman was caught between the crossfire and was killed on Pennsylvania Avenue, symptoms were stemming from the broken window policies in the early 2000s in Baltimore City. Impact is hard to calculate. It's incalculable. All I have to say is that my name is Shakur Story. This is my story.